The draft Online Safety Act 2023, Category 1, Category 2A and Category 2B Threshold Conditions Regulations 2025.
Call the Minister.
Thank you, Sir Chris, and thank you for coming to save the day today. And it's an honour to serve under your chairmanship. So, Chris, I beg to move that the Delegated Legislation Committee does consider the draft online safety threshold conditions as laid before Parliament on 16 December last year. As the Online Safety Act sets out, the Secretary of State must set thresholds for 3 categories of service: Category 1, 2A and 2B. These services that fall into each of these categories will be required to comply with additional duties, with Category 1 services having the most duties placed on them. These duties are in addition to the core duties which apply to all user-to-user and search services in scope. The Act requires that specific factors must be taken into account by the Secretary of State when deciding thresholds for each category. The threshold conditions for user-to-user services must be set out on user numbers, functionalities, as well as any other characteristics or factors related to the user-to-user part of the service the Secretary of State deems relevant. For Category 1, the key consideration is the likely impact of the number of users of the user-to-user part of the service and its functionalities on how quickly, easily and widely regulated user-generated content is disseminated by means of the service. For Category 2A, the key consideration is the likely impact of the number of users of the search engine on the level of risk of harm to individuals from search content that is illegal or harmful to children. And for Category 2B, the key consideration is the likely impact of the number of users of the user-to-user part of the service and its functionalities on the level of risk of harm to individuals from illegal content or content that is harmful to children disseminated by means of the service. These conditions form the basis of Ofcom's independent research and advice as published in March last year, which the Secretary of State was required to consider when setting threshold conditions. In laying these regulations, Sir Chris, before Parliament, the Secretary of State has considered the research carried out and the advice from Ofcom and has agreed to Ofcom's recommendations. I understand that this decision will not please everyone. And particularly, I recognise that the thresholds are unlikely to capture so-called small but risky services, as per Baroness Morgan's successful amendment, which made it possible to create a threshold condition by reference only to functionalities and any other factors or characteristics. However, it is important to note that all regulated user-to-user and search services, no matter their size, will be subject to existing illegal content duties and, where relevant, child safety duties. The categories do not change that fact. If the Code on Illegal Content Duties currently laid in Parliament passes without objections, the duties will be in effect by this spring. They will force services to put in place systems and processes to tackle illegal content. If a service is likely to be accessed by children, the child safety duties will require services to conduct a child safety risk assessment and provide safety measures for child users. We expect these will come into effect this summer on the basis that the code for the duties will be passed by then. Together, the illegal content and child safety duties will mark the biggest material change in online safety for UK citizens since the internet era began. We expect the Online Safety Act to cover more than 100,000 services of various sizes, showing the legislation goes far and wide to ensure important protections for users, particularly children online. The instrument we are debating today, Sir Chris, will enable additional duties for categorised services. All categorised services must comply with transparency reporting duties. They must also have terms of parents' ability to access information about children's use of a service in the event of a child's death. Category 1 services will have the most additional requirements. They will have to put they will have to give adults more choice about the content they see and people they interact with, and protect journalistic and news publisher content and content of democratic importance. The duties will also ensure that we can hold these companies to account over their terms of service, ensuring that they keep their promises they make to their users. Once in force, these regulations will enable Ofcom to establish a public register of categorised services, which they expect to publish this summer. Ofcom will then consult on the draft codes of practice and guidance where relevant for additional duties. And Ofcom's additional work to tackle small but risky services. So, of course, the work to tackle egregious content and enhance accountability does not stop at the instrument debated today, Sir Chris. That takes me back to the small but risky services I raised earlier. The horrifying stories I have heard about these sites over a number of debates recently are truly heartbreaking. We must do everything in our power to prevent vulnerable people from falling victim to them. I was pleased to see Ofcom set out in September last year its targeted approach to tackling small but risky services. This includes a dedicated supervision task force and a commitment to move to rapid enforcement action where necessary. This was following a letter from the Secretary of State to Ofcom inquiring about these services. I am confident that the regulatory framework, combined with this bespoke task force, will work to keep all UK citizens safe online. But I must also stress that the Secretary of State will be holding these thresholds under review going forward. If there is evidence that the categories have become outdated or inadequately protect users, he will not shy away from updating the thresholds or reviewing the legislation, as he has made clear recently. Finally, Sir Chris, the online world we are looking to govern is complex and ever-changing. The Act will not solve every problem, but it will bring real benefit to children and adults who have had to contend with an unsafe online world for far too long. We should see the instruments we are debating today as a step in that process, not as something fixed or set in stone, but a first iteration, because there is much more to do. Our foremost priority, however, is the timely implementation of the Act to enforce additional duties as soon as possible. Years of delay and indecision have already come at a heartbreaking cost for vulnerable children and adults. Now it's time to deliver. This relies on Parliament approving the categorisation threshold without delay. Thank you, Sir Chris.
The question is, the committee has considered the draft Online Safety Act 2023, Category 1, Category 2A and Category 2B threshold conditions, Regulations 2025. Benabez Jagti.
It's a pleasure to serve under your chairmanship, Sir Christopher. The Online Safety Act will be one of the lasting accomplishments of the last government. It is world-leading legislation which places significant new responsibilities and duties on social media platforms and search services to increase safety online. However, most importantly, this vital piece of legislation ensures that children are better protected online. If it is worrying that children aged 8 to 17 spend between 2 and 5 hours online per day, then it is deeply concerning that half of 13-year-olds report seeing hardcore, misogynistic, pornographic material on social media sites. It is for these reasons that Conservative ministers ensure that the strongest measures in the Online Safety Act protect children. For example, platforms will be required to prevent children from accessing harmful and age-inappropriate content and provide parents and children with clear and accessible ways to report problems online when they do arise. Furthermore, the Act requires all in-scope services that allow pornography to use highly effective age assurance to prevent children from accessing it, including services that host user-generated content and services which publish pornography. Ofcom has robust enforcement powers available against companies who fail to fulfil their duties. The Act also includes provisions to protect adult users, as it ensures that major platforms are more transparent about which kinds of potentially harmful content they allow. It gives users more control over the types of content they want to see. The Act allocates regulated services into different categories to ensure that regulatory requirements are applied proportionally. The thresholds we are debating today allow Ofcom's work and consultation in determining what platforms are set as Category 1, Category 2A and Category 2B. The highest risk platforms, the largest social media and pornography sites, will be designated as Category 1 and will bear the highest duty of care. Category 2A will contain the highest risk search engines such as Google and Bing, and Category 2B the remaining high risk and high reach sites. These regulations enable Ofcom to designate services subject to additional duties, addressing content that promotes, encourages or provides instructions for suicide, self-harm or eating disorders, as well as content that is abusive or incites hate. Where users are likely to access this content, Category 1 providers will be required to proactively offer adults optional resources or optional features to reduce the likelihood of users encountering such content or alert them to its nature. There are concerns that Category 1 sites may emit smaller platforms with harmful content, and it may be prudent for the government to look at redefining this at a later date. The Online Safety Act's impact assessment concludes that more than 25,000 companies may be within scope of the new regulatory framework. Of course, those companies that are designated into higher categories will face additional risks as they face more duties. I wonder if the Minister can reassure tech companies, especially those small and medium-sized businesses, that her department will continue to work with them to ensure the cost is affordable and proportional. I did note that Ofcom expects the illegal harm safety duties to become enforceable around March 2025, once the technology companies have assessed the risk of online harms on their platforms. Does the Minister agree with me that platforms do not need to wait and should already be taking action to improve safety on their sites? And can the Minister confirm that she is encouraging platforms to take this proactive action? Separate to the Online Safety Act, the last government launched the Pornography Review to explore the effectiveness of regulation, legislation and the law enforcement response to pornography. I understand that review is now concluded. Can the Minister provide her reassurance that the review's final report will be published imminently? I would be grateful for the Minister's comments on these points. The Online Safety Act is a pivotal piece of legislation and makes the UK the safest place in the world to be a child online. I am proud of the previous government's role in passing it, and I urge the Minister to ensure it is fully implemented as soon as possible. Thank you.
Martin Ridley.
Thank you, Chair. Pleasure to serve under your chairship. I am disappointed in this instrument. I'd like to start off, I acknowledge the Minister acknowledging the small sites high harm issue, but I think this is something that is far more important and we are missing an opportunity here. So I'd like to start by asking if the Minister can set out why the regulations as drafted do not follow the will of Parliament, accepted by the previous government and written into the Act, that the threshold for categorisation can be based on risk or size. This was a long-argued point. I have more words here than I can say, but it was a long-argued point that went through many iterations. The then Government Minister accepted the amendment that was put forward and said, many in the House have steadfastly campaigned on the issue of small but risky platforms. He confirmed the legislation would now give the Secretary of State the discretion to decide whether to set a threshold based on the number of users or the functionalities offered, or both factors, and the change ensuring that the framework is as flexible as possible in responding to the risk landscape. That has been thrown away in this new legislation. The Minister just said that we must do everything in our power, and yet they are throwing out a crucial change that was made to the Act to actually give them more power. So you are getting rid of a power that you have by changing this in this way. The amendment was to ensure that small sites dedicated to harm For example, sites providing information on suicide or self-harm, or set up to target abuse and hatred at minority groups, like we saw in the riots in the summer, were subject to the fullest range of duties. However, when Ofcom published its advice, it disregarded this flexibility and advised the regulation should be laid, bringing only the large platforms into Category 1. This leaves us in, here somewhere.
Well, he could wait.
Please.
I'm wondering if the member is as concerned as I am about the fact that the government seems to just be ignoring the will of the House, the will of Parliament in the decision that it's taken today, and is he worried that young people particularly will suffer as a result?
Thank you for that point. Yes, absolutely I am. The Secretary of State's decision to proceed with this narrow interpretation of the Online Safety Act provisions and the failure to use the power they have to reject Ofcom's imperfect advice will allow small, risky platforms to continue to operate without the most stringent regulatory restrictions available and leave significant numbers of vulnerable users, women and individuals from minority groups, at risk of serious harm from targeted activity on these platforms. So I set a few more questions for the Minister. How does His Majesty's Government intend to assess whether Ofcom's regulatory approach to small but high harm sites is proving effective, and have any details been provided on Ofcom's schedule of research about such sites? What assessment has the Government made of the different harms occurring on small, high harm platforms? Has it broken this down by type of harm, and will it make such information available? Has the Government received legal advice about the use of service disruption orders for small but high harm sites? Does the Government expect Ofcom to take enforcement action against small but high harm sites? And has it made an assessment of the likely timescales for enforcement action? Will the Government set out criteria against which it expects Ofcom to keep its approach to small but high harm sites under continual review, as set out in its draft statement of strategic priorities for online safety? And was the Minister aware of the commitment made by the previous government that select committees in both houses would be given the opportunity to scrutinise draft Online Safety Act statutory instruments before they were laid? If so, why did this not happen in this case? Will she put on record her assurances that in future Online Safety Act statutory instruments will be shared with the relevant committees before the laying proceeds? And because of all of these reasons, I will be voting against this measure.
Mr. Blackman.
Thank you very much, Chair. I appreciate the opportunity to speak in this Statutory Instruments Committee. Like at least one other member in this room, I lived the online safety bill for a significant number of months. In fact, it seemed to drag on for quite years. This legislation, the Online Safety Act, is, as the Minister said, long, long overdue. We've needed this legislation for 30 years. We've needed this legislation since I was a kid using the internet in the early 90s. There has always been the risk of harm on online platforms. There has always been places where you can be radicalised, places where you can see misogynistic content or content that children should never be able to see. This is one of the circumstances where legislation has moved significantly slower than society has, and I completely agree with the Minister in that. But that's not a reason to say that we should accept the statutory instrument that's been put before us. That's not a reason to say that actually this statutory instrument is absolutely fine and we should just agree with the threshold conditions that are being put forward. To begin with, in terms of the threshold conditions that are set out, I'm unclear why the government has chosen 34 million for the average monthly active users, or whether why they've chosen 7 million for the number of users in terms of the content recommendations. Is it 34 million because Reddit happens to have 35 million average UK users? Is that the decision why they've taken it? And I absolutely believe that Reddit should be in scope of Category 1, and I'm pretty sure Reddit believes that Reddit should be in scope of Category 1 and require those additional duties to be placed on it as a Category 1 provider. Now, Reddit will be in scope and is one of those places where the functionalities, where the content recommendation services mean that people can see, well, no matter what age they are, can see content that can be incredibly harmful. They can see content that can be incredibly funny. There's a number of brilliant places on Reddit where you can look at pictures of cats, which is my favourite way to use the internet. However, there are dark places in Reddit forums. There are dark places where you can end up going down a rabbit hole. So I appreciate and agree that platforms like Reddit should be in the scope of Category 1. In terms of the Schedule 11 that the Minister spoke about and the changes that were made during the course of the passage of the bill, the Minister's absolutely right. It says in subsection 5 of the first clause of that schedule that in making the regulations under subparagraph 1, the Secretary of State must take into account the likely impact of the number of users, of the user-to-user part of the service and its functionalities on how easily, quickly and widely regulated user-generated content is disseminated by means of the service. But that doesn't undo the fact that earlier on in that section, we, as legislators, added a change to it. It was accepted, it was changed, and we fought for it incredibly hard. We fought for it here, we fought for it at every single opportunity, whether that was in the Bill Committee, whether that was on the floor of the House, whether that was in the Recommitted Committee, whether that was in the House of Lords. At every stage, we voted and moved for that change to be made. We pushed for it. Significant numbers of outside organisations cared deeply about this and wanted those small, high-risk platforms to be included. The change that was added was any other characteristics or parts of the service or factors relating to that part of the service that the Secretary of State considers relevant. That was what the government was willing to give us on it. It wasn't the original amendment that I moved in Bill Committee that was specifically about small, high-risk platforms, but it was enough to cover what we wanted. It was the key important thing to cover those issues. Now, in terms of those functionalities, in terms of functionalities that could be, and I think should be, brought in scope, any service that allows users to live stream, any service that allows users to live stream should, I believe, be in the scope of Category 1. We know that live streaming is where the biggest increase in self-generated child sexual abuse material is created. We know that live streaming is incredibly, incredibly dangerous for people who are desperate to get access to child sexual abuse material, to convince vulnerable young people and children to live stream. And there's not that delay where that content can be looked at, where that content can be checked in advance of it being put up. Yet the government doesn't believe that every service that allows live streaming, that allows 6-year-olds to live stream, that those services should all be within the scope of Category 1. The government doesn't believe that they should all be subject to these additional safety duties, despite the fact that Clause 10 of the Online Safety Act says, that Clause 1 of the Online Safety Act says that platforms should be safe by design. This is not creating platforms that are safe by design. This is not excluding young people from the ability to stream explicit videos to anyone, because they are only including services with over 34 million users, or 7 million where it comes to content recommendation. And I agree that those over 34 million and those with over 7 million where there's content recommendation services are problematic. I agree that that is the case. But there are other services that are really, really problematic, that cause life-changing, or in some cases, life-ending problems for children, for young people, for vulnerable adults, that will not be in scope of Category 1. Now, the government, I'm not generally a big fan of a lot of the things the UK government has done, right? You know, I've been pretty much on my feet in the chamber arguing against a significant number of things the UK government has done. This is one of the things that makes me most angry, because the government is legislating, is putting forward this secondary legislation in opposition to the will and the intention of the Houses of Parliament. And I know that you can't bind a future government, I know that you can't bind a future House, but this is not what was intended. This is not what was agreed and moved on. This is not what royal assent was given on. Royal assent was given on the basis that we had assurances from government ministers that they would look at those functionalities, that they would look at those small but high-risk platforms. And for whatever Ofcom has done in terms of putting out guidance or information on what they're doing in small but high-risk platforms, why aren't we using everything? Why aren't we using everything that is available to us? Why isn't the government willing to use everything that's available to us to bring these very high-risk platforms into the scope of Category 1? In terms of Category 1, the changes that they would be required to do is there's additional duties for Category 1 services. For a start, they are under more scrutiny, which is to be expected. They're put on a list of Category 1 services. There is a specific list of Category 1 services that will be published. Now, to begin with, if that list of Category 1 services includes platforms like 4chan that some people may never have heard of, responsible parents will see that list and say, hold on a second, why is 4chan on there? I don't want my child to be going on there. It's clearly not a ginormous platform, therefore it must be on there because it's a high-risk service. Parents will look at that and will talk to their children about those. So just in terms of the list of Category 1, never mind the additional duties, that would have a positive impact. Putting suicide forums on that list of Category 1 services would have a positive impact on the behaviour of parents and the behaviour of children and the behaviour of teachers that are teaching those young people how to access the internet safely. Guarantee you a significant number of teachers and people that are involved with young people who never even heard of 4chan. But putting it on that list would give them an additional tool to be able to approach young people, to be able to talk to young people about the ways in which they use the internet. The ways. Yeah.
Thank you for giving way and for speaking so passionately about this. And as a Liberal Democrat mental health spokesperson, this is something that we're increasingly coming across. It's not just adults asking children to live stream, but peer-to-peer children not realising that this is illegal. And as you touched on, the mental health impacts of this are huge, but they're also lifelong. You have a digital footprint that you can never get rid of. Children who are uninformed and uneducated as to the impacts of what their decisions could be going decades into the future.
I completely agree, and that's one of the additional reasons why live streaming is one of my biggest concerns and should have just been included in the functionalities as a matter of course. If you talk to any of the organisations like the Internet Watch Foundation, for example, that deal with young people and deal with removal of child sexual abuse material online, they will tell you that live streaming is an absolutely huge problem. And the member is 100% correct, and that's the way that I talk to my children about online safety, is that once you put something online, once something is on the internet, you can never take it back. That is there forever, no matter what you do about it. And young people may not have the capacity to understand that. If these systems were safe by design, then young people simply would not have access to live streaming at all. They would not have access to that functionality, so that there could be that moment of thinking before they do something, so that they could, not do peer-to-peer live streaming that can be then shared amongst the entire school, amongst the entire world. We know from research that has been done the significant number of child sexual abuse materials that are impossible to take down. Young people who have put their own images online, or somebody else has shared their images without their consent, and organisations like the Internet Watch Foundation do everything that they can to try and take down that content. But it's like playing whack-a-mole. It comes up and up and up and up. And once you've done that, once you've fallen into that trap, you cannot take it back. If we were being safe by design, we would be ensuring that no young person, or as far as possible, as far as the government could do, as far as we could do, as far as Ofcom could do, no young person would be able to access that functionality. That, as I say, should just have been included. Now, I appreciate what the government said in terms of some of the content recommendation things and the algorithmic, the algorithms that are used in order to ensure that people basically stay on platforms for a significant length of time, right? I don't know how many of you have spent much time on TikTok, but you start watching videos of cats, and an hour and a half later, you're still watching videos of cats on TikTok. The algorithms are there to try and keep you on the platform. They are there because actually they make money from you seeing the advertisements. They want you to see exciting content. Now, part of the issue with that content recommendation is that they're serving you more and more exciting and extreme content in order to try and keep you on that platform for longer. So we end up, in terms of the content recommendation that's been spoken about and been referenced in the conditions that have been written, we end up with a situation where people are radicalised on these platforms because, and possibly not intentionally by the platforms, because their algorithm just serves more and more extreme content. Now, I agree that that should have a lower threshold in terms of the number of users, and I think that the government has got those. I'm not sure about the numbers of the thresholds, but has got that kind of differentiation correct, particularly in that addictive nature of algorithmic content. However, they are failing when it comes to this incredibly high-risk content. So the additional duties in terms of Category 1 involve a number of different things. Illegal content risk assessments, being published and being part of the terms of service, children's risk assessments, adult empowerment duties, and record-keeping duties. Now, in addition, as I said, to the fact that those Category 1 ranked platforms will be on a list, which I think is powerful in itself. Adding those additional duties, I think is really, really important, right? If somebody is undertaking a risky business, if somebody's undertaking, so let's say you've got an organisation that does piercing, for example. The government requires piercing organisations because they're involved in things that are dangerous, because there's a risk of infection, because of all of the additional risks associated with that. Even though not very many people get piercings in the grand scheme of things, the government requires those organisations to jump through additional hoops. It requires them to meet hygiene regulations. It requires them to ensure they're registered with environmental health, to have checks of their records to ensure that they know who is being provided with these piercings, because it's a risky thing. The government's putting additional duties on them because they recognise that it's risky and potentially harmful. The government is choosing not to put additional duties on incredibly high-risk platforms. It's choosing not to do that. It's got the opportunity to do that. We've given it the right to do that. Parliament has made its will very, very clear. We want the government to take action over those small, high-risk platforms. I don't care how many hoops 4chan has to jump through. Give them as many hoops as you possibly can. They are an incredibly harmful site. There's many other ones out there. The members mentioned suicide forums, for example. Make them jump through every single hoop. If we can't ban them outright, right, which would be my preferred option, but if we can't do that, make them keep records, make them have adult empowerment duties, make them be on a list of organisations that we reckon, that the government reckons, that Ofcom reckons, is a harmful list of organisations. Because if we end up in a situation where, due to the failures of this act, young people commit suicide, and then the forum or the platform is not categorised properly, then there's a reduction in the amount of protections and information they have to provide about deceased children, for example, to the families, because they're not categorised in the Category 1 or 2B categories. So we could end up in a situation where a young person dies as a result of being radicalised on a forum because the government decided it shouldn't be in scope, and then that platform doesn't even have to provide access to the deceased child's family of their online usage. Now, that's shocking, right? At least to bring them into scope of the actions and requirements in relation to deceased children, if you're not willing to do the proper actions that are required. Mr. Chair, I appreciate that I have taken a significant length of time, not nearly as long as the online safety bill has taken to pass, I hasten to say, but I'm absolutely serious about the fact that I'm really, really angry about this. This is endangering children. This is endangering young people. This is turning the Online Safety Act back into what some people suggested it should be at the beginning, which is a anti-Facebook, anti-Twitter, or regulation of Facebook and Twitter, X, act, rather than something that genuinely creates what it says in Clause 1 of the Act, which is an online world that is safe by design. This is not creating an online world that is safe by design. This is opening young people, this is opening vulnerable adults up to far more risks than it should. The government is willfully making this choice, and we're giving them the opportunity to undo this, to choose to make the right decision, the decision that Parliament has asked them to make, and to include functionalities like live streaming, and to include those high-risk platforms that we know radicalise people and put them at higher risk of death.
Jeremy Wright.
Thank you very much, Sir Christopher. It's a great and unexpected pleasure to serve under your chairmanship, and I want to take the opportunity to say something about why I think these regulations are a mistake. I agree with a great deal of what the Honourable Lady for Aberdeen North has just said. I will seek not to repeat it. But it's probably worth noting at the outset that, as the Minister has quite rightly explained, this is not the only means by which we will hold online services to account under this piece of legislation. And Category 1 designation allows Ofcom, the regulator, to impose additional constraints on a platform. I think that is an entirely fair point to make. But she's also observed that there are something like 100,000 services, online services, likely to be in the scope of this Act overall. It's worth noticing that on Ofcom's assessment, something like 12 to 16 services only would qualify for Category 1 status if, as is currently the case, size was the only criterion, and that we set the limit, as these regulations seek to do, at 7 million monthly users. And as the Honourable Lady has just explained, over a considerable period of time, with a considerable amount of energy expended, Parliament decided it was appropriate to include in the Category 1 designation not just the largest services, but also those services where a great deal of harm may be concentrated, but were in themselves much smaller services. And that might happen organically, or it might of course happen because that harmful content seeks refuge from the regulation given to the larger services by migrating to a smaller one. So there is good reason to think that having smaller services potentially included in Category 1 designation is a tool that Ofcom and indeed the government will want to have available to it. And those platforms, like those that specialise in suicide or self-harm, may very well be the kind of platforms that we find ourselves increasingly concerned about, and that the government will increasingly be asked to do something about. And I have to say to the Minister that it is not sensible to remove from the government's hands, and indeed from the regulator's hands, the tools it may want to use to do what the government will undoubtedly be asking it to do, and which the government will itself be coming under pressure to do something about. And again, as has been explained, what you include in the Category 1 designation, who you include in that designation, really matters because of the additional powers and constraints that Ofcom will have available to it in relation to Category 1 services. And those powers include the only powers currently available under this Act to protect adults from anything that is not illegal content, including vulnerable adults, by the way. And there will come a time where the government, I suspect, will wish it had more to deal with problems of that nature. And again, as the Honourable Lady has explained, this Act gives those powers. It is bizarre in the extreme that the government should choose voluntarily not to use those powers. Bizarre also because the Labour Party in opposition was very clear in its support for this change. The Honourable Member for Newton Abbott quoted one example of what the shadow spokesman at the time, the Honourable Lady for Pontypridd, who now has government responsibilities elsewhere, said in the passage of the bill. Perhaps I can quote to the committee another example. What she said was that categorisation of services based on size rather than risk of harm will mean that the bill will fail to address some of the most extreme harms on the internet, end quote. Well, I think she was absolutely right then, and she's still right. And this regulation, I'm afraid, does exactly what she said the Act should not do. It limits to size only as a criterion the designation of Category 1, giving those additional powers. And then we should think about the government's rationale for what it's doing today. And the Secretary of State made a statement in December which set out the reasoning for the measures that the government is now putting before the committee. And what he said in that statement was, and I quote, "In making these regulations, I've considered factors as required by the Act. Amendments made during the passage of the Act changed the consideration for Category 1 from," and he quotes, "the level of risk of harm to adults from priority content that is harmful to adults disseminated by means of the service, to," and he quotes again, "how easily, quickly and widely regulated user-generated content is disseminated by means of the service." And he goes on to say this was a significant change. In other words, what he's arguing, I think, is that he has no option but to limit to a scale criterion only designation for Category 1, because that's how the Act has changed. I think that is fundamentally mistaken, if I may say so to the Minister. What the Act says in Schedule 11, which is the relevant schedule, specifically 11.1.5, and I don't expect the Minister to have all this in front of her, but I know her officials will take careful note of this. What that part of the schedule says is that in making regulations under subparagraph 1, which are the regulations we're discussing today, the Secretary of State must take into account the likely impact of the number of users of the user-to-user part of the service and its functionalities on, and this is the part that the Secretary of State has drawn out in his statement, on how easily, quickly and widely regulated user-generated content is disseminated by means of the service. So it's undoubtedly something the Secretary of State has to take into account. It is not the only criterion the Secretary of State has to take into account. And I think there is a fundamental misunderstanding, at least I hope that's what it is, in the ministerial statement, which suggests that that's the only criterion to be considered. It isn't. And I think it's a mistake to ignore the others, which again have already been drawn out in this debate. And let's be clear, this order means that no smaller platform under the level of 7 million monthly users can ever be considered as a Category 1 platform unless or until the government and Ofcom change their approach to the categorisation process. And I repeat the point, and I make no apologies for doing so, that that is specifically contrary to what Parliament had intended in the passage of this Act. And again, as has been observed, I'm not the only one saying it. The Honourable Lady for Aberdeen North is not the only one saying it. There are multiple organisations with whom we worked closely, with whom the Labour Party worked closely in order to get this Act passed for the protection of those that they are charged with worrying about. Organisations like the Samaritans, Mind, the Centre for Countering Digital Hate, Anti-Semitism Policy Trust and the Molly Rose Foundation, all organisations that care deeply about the effectiveness of this legislation, as I'm sure do we all. It is true, and the Minister may make this point, that Ofcom's advice suggested the course of action the government is now taking. But advice is the key word. The government was not obliged to take it, and in this instance I think it would have been wiser to resist it. What this situation means is that Ofcom will not have all the tools it could have to deal with smaller services where greater harm may be concentrated, despite what the Act allows. And I have to say that tying one hand behind Ofcom's back is not sensible, even when Ofcom is itself asking us to do so. And that's especially true when the government places, as it's entitled to, such heavy reliance on the Online Safety Act to deal with the multiple online harms which arise. I have lost count, as I suspect others in this committee have, of the number of times that ministers have referred to the Online Safety Act when challenged about harmful material or behaviours online, and have said, this is the answer. This Act gives us powers to act against services that do not do what they should. And they are right. It is not a perfect piece of legislation. None of us involved in its generation would claim so. but it does give powers for government and regulators to act. But that does us no good at all if in subsequent pieces of statutory legislation the government chooses to not use those tools or put them beyond Ofcom's reach. That is what this measure today does. And I have to say to the Minister, government is hard enough. Do not throw away the tools you need to do the job you've promised everyone you will do. This is a mistake, and I hope that even at this late stage, the Minister will find a way of avoiding making it.
Robin Swan.
Thank you very much, Sir Christopher. A pleasure to serve under your chairship. And I won't repeat many of the points that have already been made, but I just want to rise to again express my concern that these changes do not bring into scope those small but potentially dangerous platforms. Those platforms that bring about those specific targeted abuse and harms, and even those platforms that disguise themselves as support for those who seek to look to how do they prevent self-harm, how do they prevent suicide, how they move away from eating disorders. But actually when you get further into those sites, are actually sites that promote that ideology and actually cause further harm. So I think, as the previous speaker has just said, I think there's an opportunity that has been missed here by the government, that they continue to reference that this bill or these SIs should be about correcting. But also to echo the comments from the Honourable Member of Aberdeen North in regards to what I see as a blunt tool, those setting of the 7 million limit and a 34 million limit. So Christopher, when we read into the regulations and the description there, those figures are worked on a 6-month mean average, so there's absolutely nothing preventing one of these platforms who, should they want to flout or get below a threshold, simply to try and delist or deregister a number of their users over that 6-month rolling period that would actually see them fall out of scope of these regulations. So I think, listening to previous speakers, I wasn't in this place previously, but in regards to using these pieces of legislation that came from the Online Harms Act in regards to looking rather at the level of risk, rather than using numbers as a blank term, I would encourage the government, like previous speakers, to go back to look at what this legislation is actually about achieving, and that's protecting our online users.
Right. Thank you, Sir Christopher. Can I just first of all thank all the members for their very powerful contributions and very valuable contributions to the debate. As I said, Sir Christopher, this instrument will bring us one step closer to a safer online world for our citizens. It is clearer than ever that this legislation is desperately needed. Transparency, accountability and user empowerment matter now more than ever. I will now just quickly go through a response to the points that were raised by the honourable members. The honourable member, the opposition spokesperson, raised the issue around whether we agree that whether I agree on the need for companies not to wait for the duties to be start implemented, but to ensure that safety is baked from the start. Absolutely agree with him on that, and you'll be aware that the Secretary of State has made this point on many occasions. He also raised the issue of proportionality. And I can confirm that many of the duties on categorised services are subjected to the principle of proportionality. This requires Ofcom to consider measures which are technically feasible to providers of a certain size or capacity, and in some cases duties are based on the assessment of risk of harm presented by the service. For example, in determining what is proportionate for user empowerment content duty for Category 1, the findings of the most recent user empowerment assessments are relevant, which includes the incidence of relevant content on service in addition to the size and capacity of the provider. And where a code of practice is relevant to a duty, Ofcom must have regard to the principles on proportionality, and and what is proportionate for one kind of service might not be for another. On the pornography review, it's absolutely right, that has been completed, and the government is reviewing at the moment and will publish it in due course. Right, in response to the member for Newton Abbott and Aberdeen North and member for Kenilworth and Southam all raised this. So when the Online Safety Act was introduced, Category 1 thresholds were due to be assessed based on the level of risk and harm for adults, as the members read out very clearly. This was removed during the passage of the Act by the previous government. So as it stands at the moment, whilst Baroness Morgan's successful amendment made it possible for thresholds to be based on for threshold conditions to be based solely on functionalities, it did not change the basis of Ofcom's research, which for Category 1 is easy, quick and wide dissemination of content. And the Secretary of State had to consider this. And I will repeat this for all members to hear again. The Secretary of State has to act within the powers given to him in Schedule 11 and in setting out threshold and conditions. The powers do not allow for threshold to be determined by another body as requested as per the amendment. So whilst the member for Aberdeen North was very powerfully reading the Act, it's very clearly sets out that it doesn't actually do what she's asking for it to do. We absolutely agree that the small but risky sites should need to be covered, but as it stands at the moment, the Secretary of State does not have the powers to include them in that. I will come back, sir. I've got a lot of points to cover. If I've not covered in my response, she's more than welcome to intervene later on. These small but risky services are of significant concern to the government, as I said, and they will still have to protect against illegal content and, where relevant, content that is harmful to children. Ofcom also has a dedicated task force to go after them. So, again, I hope that answers the honourable member's question. The member for Newton Abbott also raised the review of Ofcom's approach. So the regulator has already trialled the approach of targeting small but risky services through their regulation of video sharing platforms, and indeed a number of small risky services improve their policies and content moderation in response. Specifically, through this route, all of the adult platforms under a VSP regime, large and small, have implemented age verification to ensure that under 18s cannot access pornography on their services. In instances where services fail to make necessary changes, they face formal enforcement action from Ofcom. Ofcom has a proven track record, and the government has every faith in their ability to take action against non-compliant services. The member also raised issues around how Ofcom will enforce against small but risky services. Ofcom will have robust enforcement powers available to use against companies who fail to fulfil their duties, and will be able to issue enforcement decisions. This may include fines of up to £18 million or 10% of qualifying worldwide revenue in relevant year, whichever is higher, and directing companies to take specific steps to comply with its regulation. In extreme cases...
I thank the Minister for giving way. A couple of points there that have been raised. She raised age verification, which is good. She did not quote how harmful to adults and harmful to vulnerable minorities, harmful to women, is categorised. Yes, the children are protected in that case, but those others are not. Also, in the answer she just provided, the difficulty is not the Ofcom powers, it is the obligation on the provider. So if we have not put them into Category 1, they do not have the same levels of obligation. No matter what powers and fines Ofcom provide, they cannot get them to give those commitments to a Category 1 level if they are not in that category. removing this clause is not giving them the tools, and she's absolutely right when she said earlier on there is much more to do, so why drop this ability to put other sites in that category 1?
Esther.
Thank you, Sir Christopher. I think the member missed the point when I said it is not, the Secretary of State does not have power as it stands to include them. It is not removing them. It is not having the powers to include them as it stands at the moment. I will conclude. In extreme cases, Ofcom, with agreement of the courts, use business disruption measures. These are court orders that mean third parties have to withdraw their services or restrict or block access to non-compliant services in the UK. And then the member also raised the in relation to whether the Act will be reviewed to address the gaps. Our immediate focus, as I said at the start, is getting the Online Safety Act implemented quickly and effectively. The Online Safety Act was designed to tackle illegal content and protect children, and we want those protections in place as soon as possible. It is right that the government continually assesses the framework's ability to keep us, especially given technology moves so fast. We will, of course, look at how effective those protections are and build on the Online Safety Act based on evidence. However, our message to social media companies remains clear. There is no need to wait, as the spokesperson for opposition say. They can and should take immediate action to protect their users. Use of business disruption measures. The Act provides Ofcom with powers to apply to court, as I said, for these measures, including where there is continued failure of non-compliance and other groups. We expect Ofcom to use all available enforcement mechanisms. The member for Huntingdon also raised the issue around how Parliament can scrutinise the delivery of this legislation. So ongoing parliamentary scrutiny is absolutely crucial. Indeed, the Online Safety Act requires Ofcom codes to be laid in Parliament for scrutiny. The Science, Innovation and Technology Select Committee and the Lords Communication and Digital Committee will play a vital role in scrutinising the regime. Ofcom's codes of practice for illegal content duties were laid in Parliament in December. Subject to them passing without objection, we expect these to be enforced by spring 2025, with the child safety codes expected to be laid in Parliament in April to be in effect by summer 2025. The Secretary of State is required under Section 178 of the Act to review the effectiveness of its regulatory framework between 2 and 5 years after key provisions of the Act coming into force. This will be published as a report and laid before Parliament. On these regulations specifically, letters were sent in advance of laying the regulations to the House of Lords, Communications and the Digital Committee, and the House of Commons, Science, Innovation and Technology Committee. The member raised a question over the user numbers. Ofcom recommended that the threshold of 34 million or 7 million for Category 1 services must exceed the user number thresholds. The government is not in a position to confirm who will be categorised. This is the statutory role of Ofcom once the regulations have passed. I'm gonna make some progress, I'm afraid. On live streaming, Ofcom considered these functionalities, but concluded that the key functionalities that spread content easily, quickly, and widely are content recommender systems and forwarding or resharing user-generated content. Services accessed by children must still be safe by design, regardless of whether they are categorised or not. Small but risky services will also still be required to comply with illegal content duties. Members should be very well aware of that, and I should raise concerns over that. On child safety, there was the questions around, again, how online safety protects children from harmful content. The Act requires all services in scope to proactively remove and prevent users from being exposed to priority illegal content, such as illegal suicide content and child sexual exploitation and abuse material. So that is already within the remit. In addition, companies that are likely to be accessed by children will need to take steps to protect children from harmful content and behaviour on their services, including content that is legal but nonetheless presents a risk of harm to children. The Act designates content that promotes suicide or self-harm as categories of primary priority content that is harmful to children. Parents and children will also be able to report pro-suicide or pro-self-harm content to the platform, and the reporting mechanism will need to be easy to navigate for child users. On 8th of May, Ofcom published its draft Children's Safety Codes of Conduct. In this publication, Ofcom proposed measures that companies should employ to protect children from suicide and self-harm content, as well as other content to children. And then finally, so Chris, on the why the Category 1 is not based on risk, such as the risk of hate speech. When the online safety was introduced, the Category 1 thresholds were due to be assessed based on the level of risk, as I said earlier, level of risk of harm to adults from priority content disseminated by means of that service. As I said earlier, this was removed during the passage of the Act by the then government and was replaced with consideration of the likely functionalities on how easily, quickly and widely user-generated content is disseminated, which is a significant change. And while the government understands that this approach has its critics, who argue that the risk of harm is the most significant factor, this is the position under the Act. Absolutely.
Specifically on this one, she's making the case that the Secretary of State's hands are tied by the Act, that it requires stuff in relation to the number of users. Can she tell us which part of the Act it says that? Because it doesn't say that. If she can tell us where it is in the Act, I'm quite willing to sit down and shut up about this, but it's not in the Act.
Thank you very much. Okay, so the legislation allowed the Secretary of State to deviate from Ofcom advice and publish a statement explaining why. However, the core consideration for Category 1 under Schedule 11 is how easily, I'll repeat third time, how easily, quickly and widely regulated user-generated content is disseminated by means of the service. As a result, for Category 1, Ofcom concluded that the content is disseminated with increased breadth as the number of users increases. The decision to proceed with the threshold combination recommended by Ofcom rather than discounting user number threshold reflects that any threshold condition created by government should consider the factors as set out in the Act, including easy, quick and wide dissemination for Category 1 and be evidence-based. That is what the Act says. That is what the Act says.
This is taken into account.
Right. As a result, the government decided not to pursue the approach which deviated from Ofcom's recommendations, particularly considering risk of unintended consequences. I am more than happy to write to the member with full detail. I understand that the member, feels very passionate about this, but the Act is the Act, and I will want so I'm very grateful for their contribution. I have to follow what the Act says based on the legal advice I get. So Christopher, I will, of course.
I'm
I'm extremely grateful, and I have sympathy with her position, especially in relation to legal advice, having both received it and given it. But can I suggest to her that there are two different things that she's talking about, and they need to be separated. The first is the question of whether or not legal but harmful content was removed from the bill, which it undoubtedly was. So in relation to that content that is neither unlawful nor harmful to children, in large measure, that was removed from the bill. She's right to say that. What we are discussing today, however, are the tools available to Ofcom to deal with those platforms that it still is concerned about in relation to the remaining content that is within the ambit of the bill. And our worry, I think, for those of us who've spoken on this at least, is that the government is about to remove one of the tools that Ofcom would have had to deal with smaller, high-harm platforms when the harm in question is harm which remains within the ambit of the bill, not that which was taken out during its passage. Would you accept that?
Yes.
Thank you, Sir Christopher. I will again set out what the Secretary of State's powers are. So the government did consider, and clearly has considered, Baroness Morgan's and other categorisation, others to categorise small but risky based on coroners or Ofcom linking a service to a death order. The government was grateful for this suggestion. However, there were, so no, it wasn't, but however, there were issues with this approach, including that the Secretary has said within the Act, the power, what it allows the Secretary of State to consider when setting the categories, it does not allow Secretary of State to consider anything else other than, as I said, the factors that set out in the Act, which say it has to be within, whether it includes easy, quick and wide dissemination for Category 1, and has to be evidence-based. I am more than happy to provide the, it is what it says, and I mean, I'm sure, I hope the member for Aberdeen North will accept that I will write to her in very great detail for the letter from our lawyers, setting out, from the government lawyers, setting out whether what I'm saying in relation to what the government, what the Secretary of State powers are in setting these categories, and I hope she'll be satisfied with that. It is not, and I would like to make it clear that the Secretary of State, we are not taking anything out. The Secretary of State is proceeding with the powers that he has been given. I am going to proceed, Sir Christopher, if you allow me. So I'm going to go to, I think I've covered the main points of that the honourable members have raised. I hope the committee agrees with me that the importance of enacting these thresholds and implementing the Online Safety Act as swiftly as possible. And I also made it clear that the Ofcom have set up a task force that will be reviewing the small but risky sites in response to Secretary of State's letter to them in September. With that, Sir Christopher, I commend these regulations to the House.
Give way before she sits down.
Ashley Cox, Sir Ashley Cox.
Thank you, Sir Christopher. It's an honour to serve under your chairmanship. My right honourable friend was Attorney General for 4 years, and it is just possible that his interpretation of the Act is correct, and that of the Minister's officials is incorrect. Now, I don't have detailed knowledge of this legislation, but I just wondered if the Minister and her whip wanted to take a moment to pause and take an adjournment before putting this to a vote, to take some further time. That would be perfectly acceptable with us. We're not going to oppose these regulations, but we're just cautious. If the Minister wants more time, she's welcome to take it.
Whilst I thank the honourable member for his contribution, I'm sure he will appreciate that both this issue has been looked into, has been debated, has been discussed, both in both in debate but also with the officials. So thank him for his contribution. And with that, Sir Christopher, I commend these regulations to the House.
The debate can continue until 7 minutes past 11, and for the benefit of new members, if there's anybody else wishes to speak again, it's possible to speak for a second time in a standing committee. Kirsty Blackman.
Thank you very much, Chair. I appreciate that prod. I did have a look at standing orders this morning, but couldn't quite find that bit, so that's incredibly helpful. Just in terms of what the Minister's just said about Schedule 11 and the notes that she's been passed from her team on this, I appreciate her commitment to share the government's legal advice. I think that's incredibly helpful. It would have been helpful to have it in advance of this meeting rather than have it just now. In Schedule 11, as the Honourable Member says, it says, in making regulations under subparagraph 1, the Secretary of State must take into account the likely impact of the number of users of the user-to-user part of the service as functionalities on how easily and quickly and widely regulated user-generated content is disseminated by means of the service. Now, maybe I can't read English and the Minister reads it in a different way to me. Maybe the legal advisors and the team at DCIT read it in a different way to me. But the Secretary of State having to take something into account and the Secretary of State being bound by something are two different things. Those are not the same. It does not say the Secretary of State must only regulate in terms of those that have got a specific number of users. In fact, it does say earlier the Secretary of State must make regulations specifying conditions for the user-to-user part of regulated services related to each of the following: the number of users, the functionality of that part of the service, and any other characteristics of that part of the service or factors. So he must make regulations in relation to any other characteristics of that part of the service or factors relating to that part of the service that the Secretary of State considers relevant. He must do that, but he only must take into account the number of users. But the government have decided that taking into account is much more important than must do something. They've decided to actually, where Parliament's been pretty clear in the language that it's used, that, you know, I'm not terribly happy with the Online Safety Act. It's a lot better than what we've got currently, absolutely. I don't think it's perfect. I think it's far from perfect. I argued, you know, in favour of keeping, as the Minister said, the stuff about high risk and legal but harmful content for adults. I argued against the government's position on that. But the Act is the Act that we've got. And the Minister is making a point that doesn't make sense. The Secretary of State has to take into account the number of users and how quickly things are disseminated. But he must make regulations about functionalities that are, or factors that he considers relevant, right? So he doesn't consider it relevant. Because if he did consider it relevant, he would surely be bound by the must. He would surely have to make regulations about suicide forums if he considered them relevant. He would surely have to make regulations about live streaming if he considered it relevant. So either the Secretary of State doesn't consider it relevant, right? You know, it's just so frustrating that this Act doesn't do what it's supposed to do. It doesn't protect young people from live streaming. The Minister has mentioned the fact that it protects people from seeing that illegal content, but not from creating that illegal content. There's a difference there, right? If they were to put in regulations now, if they were to say in Category 1, we are including every platform that has the functionality of live streaming, or even just every platform that has child users on it, because there's lots of stuff in the Act about the number of child users, about the proportion of children that use the service. If it was to say any platform that has live streaming, that has child users, will be automatically included in Category 1 because we consider that to be high risk. Yes.
Very grateful to her for giving way, and I don't think it would be right for either of us to ask the Minister to disclose legal advice. That clearly wouldn't be appropriate, but I'm grateful for the Minister's offer to share with us the slightly more expansive description of why the government has come to the conclusion it has. But on the point that she made about what the schedule and the Act actually says, we quoted, both of us, Schedule 11.1.5, which deals with the point of whether or not the language which has found its way into the ministerial statement is the be-all and end-all of the minister's conclusions, which we both think it isn't. But if it were the case, as the minister I think is arguing, that the ability to disseminate easily, quickly and widely is essentially a synonym for the scale of the service and the number of its users, why does she think it is that the amendment which Baroness Morgan in the other place made, which is not to 5 but to 4, 11.1.4, which says specifically that the regulations may, the ones we're considering, must specify the way or ways in which the relevant threshold conditions may be met, and in relation to category 1 threshold conditions, at least one specified condition about number of users or functionality must be met. The crucial word added is or. If the number of users were required to establish what she's described, then that word or would be inappropriate, wouldn't it?
I absolutely agree, and I think that's a really helpful clarification. Do you know, if the government has decided that it's too difficult to do this, if the government's decided that it's too difficult to regulate high-risk platforms as category 1, if it's decided that it doesn't matter enough because it doesn't have enough of an impact, right? The government should stand up and tell us that, right? Rather than saying that their hands have been tied by the Act, which they manifestly haven't, the government needs to take ownership of it. If they've decided this is not important enough, or they can't be bothered having the fight with Ofcom about it, right? If that's the position that they've decided to take, they should be honest with us about it and should say, this is the position that we've decided to take. The government standing up and saying our hands have been tied is just not correct. Their hands have not been tied by this Act. It is not the case. I do appreciate that the Minister is going to get in touch with me with the legal advice, but we'll be too late then. This SI will have been through the process by the time that we get to that point. You know, and people will be put at risk in the meantime as a result of the failure of the government to take the action that it has the powers to take. It's got the powers just now. It's got the powers to take action in relation to functionality, in relation to factors. It's got the powers to take action in relation to suicide forums, in relation to live streaming, in relation to the creation of child sexual abuse material, and it's choosing not to take that. Now, if that's the position that the government has decided to take, if it's decided, as I say, that it's too difficult to do that, that it's not risky enough, that not enough people are being harmed by it, they need to hold their hands up and say, we've decided that this is the position we're going to take. Don't hide behind the legislation which doesn't say what they're telling us it says. Don't hide behind it because it's not true. Just be honest about the fact that actually the government has decided they can't be bothered taking action on this bit of it. They can't be bothered having the fight with Ofcom. It's not important enough. Right? Hiding behind the legislation is an incredibly cowardly thing to do, and it does not say that.
Madam Wrigley.
Thank you, Chair. Very briefly, the information that I've been given now, I don't have the benefit of having gone through the entirety of the Act, and I appreciate my honourable colleagues, my honourable friends' input on all of this. It is that one word, or. Amendment 245 would move from a test of size and functionality to a test of size or functionality. That is not, as far as I can hear from what the Minister has said, what is causing the problem. That should be giving them the opportunity to keep that there. In setting these categorisations just on size, they are ignoring that. The Minister also mentioned that the Act did not give the Secretary of State the power to allow somebody else to put organisation sites into these categories. And no, that's not what's being asked. It's a recommendation from Ofcom for the Secretary of State to bring those smaller types of sites into the category. What this change does is it removes the powers to stop those small sites that promote misogyny, racist hatred, those things that are very harmful, and we saw the examples of that in the summer. The Select Committee of Science, Innovation and Technology is looking into that at the moment. I know because I sit on that. However, that is being thrown away, and I think an opportunity here is being missed, and I think a misinterpretation has been had on the powers for setting these thresholds. I beg the Minister to take a moment and look again, because I think they're getting this wrong.
Does the Minister want to come back?
I will, sorry Christopher, just to say that the Honourable Member for Aberdeen and North's comments are absolutely outrageous, and you know, wouldn't expect anything less from colleagues from SNP, but just to say, I have made very clear that I would share the legal advice with the members. I also made it clear that small but risky sites that members have been talking about were raised by the Secretary of State in a letter to Ofcom in September, and Ofcom have set up a task force that will be looking at these services. And the key thing for this government is to get on with implementing the online safety. I know the Honourable Lady would like us to delay and spend lots of time delaying, but we are keen, we're interested in getting on with implementing the Act so we can keep children safe online. But with that, Sir Christopher, I will commend the regulation to the House.
The question is that the committee has considered the draft Online Safety Act 2023 Category 1, Category 2A and Category 2B threshold conditions, regulations 2025. As many opinions say aye.
Aye.
Contrary, no.
No!
Aye.
Division. Lock the doors.
Callum Anderson. Aye. Dr. Danny Chambers. Farrell Clark.
Aye.
Torquil Crichton.
Crichton, aye.
Sir Ashley Fox.
Abstention.
Amanda Hack. Aye. Laura Pike-Smith. Alex Mayer. Ben Best Jekti.
Abstention.
Taiwo Awatemi. Aye. Gurinder Singh Joseph. Aye. Robin Swan. No. Lawrence Turner. Aye. Chris Vince. Aye. Martin Wrigley.
No.
Thank you. For the benefit of those following us from outside, only members of the committee are able to cast their votes. Ayes 10, noes 3. So the ayes have it. Order.